Hey, it's John with Vision Advisors. Welcome to another Insight with Vision. There's a number of regulatory changes happening at the federal and at the state level you need to know about. And in this issue of Insight, we're going to take a few minutes to talk about those. And really, for all of us, we need to understand the cheese has moved. Consumer protection and consumer education are both driving federal and state regulators to look at other ways to protect the public. We've moved from a traditional suitability standard in the insurance and in the broker-dealer industry to an enhanced suitability standard of conduct over the last several years. The, the movement right now, and really the focus right now, is moving our industry towards a best interest standard, where we as financial professionals are doing what's in the best interest of our clients. The RIA industry has already been there, and they've been under a fiduciary standard for some time. And regulators are looking at how do we move banks, broker-dealers, and insurance professionals more towards a similar standard of conduct to those required of an investment advisor representative. So some of the changes we're seeing at the federal level and at the state level are addressing that. Number one, Reg BI. What's Reg BI? It's really one of the most sweeping moves by the SEC in some time. Really, the impetus of this one is moving the broker-dealer industry from that enhanced suitability standard it's operated under for a number of years to a best interest standard. It requires additional disclosure elements for RIAs and the IARs that are working under them, and this new regulation goes into effect on June 30, 2020. So as you're listening to this podcast or you're watching this video, if you're Series 6 or Series 7 licensed, or you have a Series 65, you need to be checking with your compliance officer to identify and understand how these changes shape the way you should be doing your client interactions going forward. The DOL rule is also being revisited and revised. In fact, the Department of Labor recently delivered an enhanced version of the DOL rule to the Office of Management and Budget for review. Now, this particular version has been retooled so that it harmonizes with the best interest standard requirements of Reg BI. Really, the goal is trying to create one standard of suitability and oversight that all of the different regulatory agencies can be involved with. The DOL rule specifically is going to mandate a best interest standard of conduct being involved with anyone working with ERISA plans. Now, there is some conversation as to whether or not this DOL rule is going to require the expansion of Reg BI requirements to those not covered currently under Reg BI. Now, if we think about that, Reg BI covers broker-dealers and to some extent enhances what the RIAs are required to do. So who's left? The insurance industry and the banking industry. So we need to keep a close eye on what the final draft of the DOL rule is to see what requirements are going to be placed upon the insurance industry and the banking industry as well. We've already talked in a prior version of Insight about the NAIC annuity sales law that was passed in early 2020. It implements a best interest standard in the sale of insurance products, specifically annuities. Requires the use of a fact finder. There's additional documentation and disclosure requirements. There's an obligation to evidence every client interaction. We talk about that in detail in a prior version of Insight. You can go to visionadvisorsinc.com, click on the YouTube button in the upper right-hand corner, go to our YouTube channel, and you can find that annuity sales law video placed there to learn specifically all of the enhancement that's going to require and mandate changes to your practice. Now, the NAIC has really made it their focus and is pushing hard over the next several months to get the majority of states to adopt this NAIC annuity sales law by the end of 2021. But many states across the country aren't waiting. They are taking action on their own, and a growing number of states are adopting their own best interest standard requirements. Some are more stringent than what we're seeing at the federal level. Some are harmonizing with those. But this push towards consumer protection, consumer education, documentation, and disclosure enhancements are coming not only at the federal level, but at the state level. Now, carriers are responding too. We're starting to see a number of carriers move from a traditional suitability form to what they are now calling a client profile, i.e. a fact finder, additional documentation, a more holistic picture of the client to be able to make a decision and to help guide the conversation as to whether or not a transaction is going to be in the best interest of a client. Of recent interest to us is the new adoption of post-issue suitability audits by a growing number of insurance carriers. Now, what is a post-issue suitability audit? It is the carrier itself or the carrier hiring an independent third party to validate the steps in the process are being completed to make sure that the financial professional engaging with the public is adhering to these new enhanced requirements. They're asking such questions in these post-issue suitability audits as, did you as a financial professional gather the pertinent facts to determine suitability? These are the questions being asked the policyholders that have received a policy and the carrier is following up with them, and they're asking, did your financial professional gather the pertinent facts and information necessary to determine suitability to help you make a decision as to whether or not this transaction was in your best interest? Did the financial professional that you met with discuss surrender charges? Did they explain not only the charge, but the schedule by which those charges are reduced over a period of time? Did your financial professional discuss with you the other available options to you if there's a 1035 exchange or a rollover option available so that you can make an informed decision regarding all of your available options? Did your financial professional discuss compensation or conflicts of interest with you if you asked or if it is a requirement in your state? These are but a few of the questions that we're seeing carriers and the third parties that they're hiring to do these validation audits do in random calls to customers to validate that these new best interest standards are being followed. So how do you respond? As a financial professional, with these enhanced regulations coming down the pipe, what are the steps in the process that you need to take to make sure that you're going to be compliant? Let us offer some suggestions. We believe you need a process. Listen to these words. You need a process that is replicatable and duplicatable. Something that you follow, a system that every time you meet with a client for a first appointment, a second appointment, a delivery, a follow-up annual review, that there is a process, there is a checklist, there is a series of procedures that you follow in every client meeting so that it becomes consistent over time. So that if there's a question, did you talk about surrender charges? Now you have a replicatable and duplicatable system whereby you can evidence and additional clients can be brought to bear if there's a question as to whether or not you did or did not do something, that they can say, yes, this client says I didn't, but here are 7 other clients that can validate through a replicatable and duplicatable process that I did. So here's some suggestions along this process line that we think would be helpful. Number one, you need to engage in fact finding. You need to build a client profile. Whether you have your own fact finder, you use the fact finder we've developed at Vision Advisors, the one required by your broker dealer or your RIA, you need to follow, again, a fact finding process to gather the pertinent information necessary to make sure that you understand the client's situation, their goals, their needs, and objectives. You've identified and quantified their risk tolerance, and you've asked specific questions to move them down a path so that they can help give you the information necessary so that you can guide them to make an informed decision. Secondly, we believe that you need to evidence all client recommendations. One of the ways that we're encouraging producers to do that now is through the use of a letter of explanation, especially if you're doing a 1035 exchange or you're doing a rollover, to write a letter explaining your conversation with the client, the steps that you walk through in the process, how you arrived at the decision that this particular transaction is in the client's best interest. Review that with the client and make sure that that's in harmony with the conversation you had, and submit that as part of the process. We're seeing a number of carriers now coming back and asking for a letter of explanation if there is a question because the information that was provided on the application was insufficient. So we believe a great way to get ahead of the curve is to do that on the front end, and it really helps provide context to someone that hasn't met your client, doesn't know your client to understand the steps that you walk through to arrive at the decision that you came to together. Number three, we think it's going to be important going forward that you document all of your client interactions. Now, that can be done through good note-taking. That can be done through a form that you create for every interaction you have with a client, or you can use an audio or video recording tool to record that. One of the advantages of audio or video is you've got an opportunity to go back and to listen to that recording to make sure that you've got the context and that you can evidence that, yes, the client and I talked about this. Here is their response to my conversation with them, and now you have got that documented and saved for posterity. Number four, we think disclosure is going to be important, and making sure that you disclose such things as surrender charges, waiting periods, policy limitations, not just the benefits and the features, but they need to understand where the gotchas are in the product as well. Not every product is perfect. We know that. Not every product is going to be 100% what they need in every situation, but the best product to fit their specific need is really where all of us are trying to go. We want to make sure we're giving the best opportunity to the client, the best solution that we can to the client based upon what's available today. Giving full and complete disclosure leaves nothing to surprise. Number five, disclosure conflicts of interest. You're getting paid to make a recommendation. If they don't buy, you don't get paid. That creates a conflict of interest. If you're getting additional compensation from a persistency bonus, a money to marketing program, or other financial incentives along the way, that potentially creates a conflict of interest. Again, disclosure on the front end is a way to avoid embarrassment of having to have that conversation on the back end. Now, at the end of the day, whether we like it or not, change is coming. And change is going to require we do really three things. Number one, we need to adapt. We need to adapt to these new regulations because they're going to govern how we do business going forward. Number two, you need to alter. You need to alter the process that you engage in your business. Your sales process needs to change to comply. And number three, you need to adjust how you're interacting with your clients and your prospects, making sure full and complete disclosure is taking place. Conflicts of interest are being discussed and outlined so that the client understands what those are. And really, to kind of summarize, using a fact finder, full and complete disclosure, explaining the available options to the client, outlining your recommendation, including a letter of explanation in the application packet, documenting through note-taking or audio or video every client interaction. Those are just good business practices. Again, replicatable and duplicatable is the key to your long-term success. And really, at the end of the day, what are we all trying to do? We're all trying to look out for the consumer. The federal regulators, the state regulators, the insurance carriers, the broker-dealers, the RIAs, the banking industry, the insurance industry, we're all trying to look out for the consumer and do the best job that we can for them. So we find a way to work inside the environment that they've given us to continue to see success, and these are not onerous rules. In fact, we at Vision are already there. One of the sales systems that we put into place a long time ago, we've recently updated, and we call it Your Retirement Reality. And in this sales system, it includes a fact finder. It includes an income analysis tool. It includes a Social Security maximization report. It includes assistance with case preparation and case design. It includes, after the fact, new business review of your applications, a pre-suitability screen before it goes to the carrier so that the business gets there in good order, and pre-screening services in advance. So if there's a question as to whether or not a carrier would even consider a specific transaction, we can go to the carrier ahead of time and ask those questions to help you know whether or not you can move forward without wasting your time or the client's time. Now, at the end of the day, it's up to you to change. We can't change you, and we won't change you. That's not what we do. But I will say this, we are here to help you adapt, to alter, and to adjust so that you can comply. Again, as I said earlier, this is not an onerous framework, but it is going to require that you retool your practice and make some changes in order to see success. It's not going to be difficult, but it is going to require that you move beyond the status quo and doing the same thing you've always done. I see this as a positive because it's going to help us continue to weed out the few bad apples that are left in the industry and give the rest of us that are doing it right a reason to implement new policies and new procedures that at the end of the day make us better. Now, we here at Vision Advisors are here to help. We want to share our insight, our knowledge, and our experience to help you adapt to these new rules as they're implemented in your state. If you've got a question or you need our assistance, let me encourage you to give us a call here at Vision Advisors, 1-800-505-8489. And if you're going to be working with an IMO, why not work with an IMO that understands compliance, that has on staff individuals that have run the compliance departments of broker-dealers and RIA firms in the past? We get the world of compliance. Are we perfect? No. Are we going to put our best effort forward to help you do everything necessary? Absolutely. And as we learn more, you're going to learn more with us. Let me also encourage you to go visit our Facebook and LinkedIn page. And if you're not following us there, please do so. We share regular updates and insights, as well as conversation starters and sales ideas on our Facebook and our LinkedIn plans throughout the week. And our YouTube channel is probably one of the broadest and deepest video learning libraries available in the industry. You don't have to be with Vision to be accessing those tools. They're there as a resource to let you see who we are and what we do. We hope after you've had a chance to check those resources out, if you're not already working with us, you will. And if you are working with us, you'll work with us even closer. Hey, I'm John Terry, and on behalf of all of us here at Vision Advisors, thanks for joining us for this version of Insight. Have a great day.